Ukraine's state-owned gas firm Naftogaz says it has won the first round of the 3-year legal battle against the Russian energy giant Gazprom. The two sides have taken their cases to the International Arbitration Court at the Stockholm Chamber of Commerce. The key achievement for Naftogaz is the cancellation of take-or-pay principle stipulated in a 2009 gas contract.
This is a big financial victory, as Ukraine will not pay dozens of billions demanded by Gazprom.
The arbitration court has also lifted the ban on the re-export of Russian gas by Ukraine and ordered a recalculation of the price formula. Kyiv wants the price to be revised since 2011, claiming that it overpaid Gazprom $14 billion since then.
According to the information from the Ukrainian Ministry of Justice, the formula will be reviewed starting from 2014. We've bought little Russian gas since then, and its price approximated to that of European hubs.
The gas deal was signed in 2009 by Ukraine's then Prime Minister Yulia Timoshenko. Kyiv says the deal was unfair, as Ukraine paid one of the highest prices in Europe, but Russia says that the price formula was economically motivated and tied to the price of oil.
Hello, I'm Alex Gupta with UATV. Today I'll be discussing the Naftogaz Gazprom arbitration case with Professor Marika Paulsen. She's a professor of law and the director of the International Arbitration Institute at the University of Miami School of Law. Today we're going to discuss Gazprom versus Naftogaz in the arbitration in Sweden. Would you be able to give us a synopsis of what this case is about?
Yes. So to begin with, there are many cases pending right now where either Ukraine, Russia, or their companies are involved. We have investment arbitration cases, there have been court litigation cases, and then there is the arbitration in Sweden. This is an arbitration that is administered by the Sweden Chamber of Commerce, which is basically the arbitration institute in Sweden that administers commercial arbitrations. This is a dispute between Gazprom from Russia and Naftogaz from Ukraine, and it is a dispute that is based on a contract between the two parties about oil and gas. The dispute relates to the pricing of the oil and gas. So Gazprom is claiming that Naftogaz hasn't paid everything. They're claiming up to 50 billion at this point in time. Naftogaz, the respondent, has filed counterclaims up to 30 billion. So we're talking at an amount in dispute of 80 billion, which makes this commercial arbitration case one of the biggest in the history of arbitration. So before that, we had the Yukos-Russia case, which was 50 billion. Gazprom is claiming that Naftogaz should have paid the price, whereas Naftogaz is claiming the price that was agreed upon in the contract, so we call that the contract price, is not the same as the market price. So this is the issue at hand. Should the party pay the market price or the contract price? My opinion is that if you look at these oil and gas contracts, so you have a contract price, which can be different from the market price, and then you have, which is the take or pay clause, which is a clause that can be agreed upon by the parties. It's freedom of contract. So the take or pay clause means that one party agrees to deliver a certain amount of oil or gas, and the other party takes it and pays. If somehow the other party decides not to take the delivery, that party still needs to pay. So what we see here, and we really need to separate the political and diplomatic issues from the actual contract. We are dealing with the contract here. These are business parties, and they have agreed upon a price, they have agreed upon a take or pay clause, and they have to comply. So this arbitration is confidential because most commercial arbitrations are. So we have not seen the contracts, we have not seen the written filings, we have not witnessed the hearing, so we don't know what has been argued. But if we just look at these kind of clauses in these kind of contracts, it really looks like Gazprom would have a more likely chance of success.
So when the arbiters, when they look at this case, they're just going to look at the contract. They're not going to take in anything else into consideration.
No, in principle, they really have to look at the contract. What would be interesting to see if one of the clauses would violate mandatory laws. So it depends what would be the substantive law that is applicable to the contract. So I'm not talking about the arbitration law, which is Swedish arbitration law. I'm talking about the substantive law applicable to the contract. If Naftogaz Council could argue that one of the clauses violates mandatory law, which would be a matter of public policy, then that council could argue that some of the provisions could be null and void. But I would think that is a long shot. And what cannot happen in cases like this when the dispute is based on a contract is that all sorts of other policy arguments are put forth. Normally, a tribunal will disregard those arguments.
So depending on who wins, can they appeal this case?
So this is a very relevant question in the times of arbitration today. Probably a decade ago, arbitration worked as follows. Parties decide to opt out of their fundamental right to access to courts. They decide to stay away from courts. They go to arbitration. Most arbitration clauses do not have an arbitral appeal, which means that once the tribunal has rendered their award, that award is binding, and that is the end of the story. So if Gazprom would win this case, Naftogaz has to comply. However, over the past years, councils have found a way to work with other, what we call de facto appeal mechanisms. So there are two. What the losing party will do, they will file for the setting aside request in Sweden, because Sweden is the seat. That is how they will try to stop the enforcement of the award. What the successful party will do, they will proceed and request for the enforcement. They will request for the enforcement in any country where there are assets. What then the losing party will do, they will try to resist the enforcement. So the de facto appeal mechanisms are two. One is request for the setting aside, and the second is resist the enforcement. And that will be done on the basis of Article 5 of the New York Convention. And the arguments used to stop or to try to not comply with the awards are mostly due process violations, public policy violations, violation of the mandate, the assignment of the arbitrators, and the argument that there was not a valid arbitration agreement. Those are the only arguments that the losing party can use.
So if the arbitration, if they decide against Naftogaz and they have to pay $30 billion, wouldn't the company go bankrupt? I mean, how can they pay that?
Well, that's another very interesting question. So, for example, there is the reality of having won an award, and then there's the second part of how are you going to get your money. In the Yukos Russia case, that was a very interesting case. Once Yukos won $50 billion, so the arbitrators had awarded Yukos $50 billion. President Putin immediately issued a press release, and said, I have not allocated $50 billion in my budget. I will not comply with the award. It was that simple. So he refused on behalf of his country to comply with that award. So then what's going to happen, the successful party is simply going to probably hire a firm that does asset searches and will freeze the assets. Then during enforcement stage, the assets are frozen, and once the courts will grant the enforcement request, they're going to execute those assets. So yes, the reality of arbitration is that this could have very serious consequences for a company.
And my final two questions. When do you expect a judgment to be made? And do you think Gazprom, they have a better shot of winning this?
I think, but again, I have not seen the briefs or witnessed the arbitration hearing. It looks like on the basis of a contract that Gazprom would have better chances. It could also be that an arbitral tribunal will split the baby, which happens a lot these days. But at this point in time, it looks like Gazprom will be more successful. Then it is not clear whether it seemed that the award was going to be rendered end of April. So that's last month. And now it looks like it's going to be rendered end of June. But since it's confidential, we will not know until either one of the parties is going to make a public statement. But that's not the end of the story. What will happen the day the award is going to be rendered, both parties are going to take action in courts. So one is going to go for the enforcement, the other one is going to go for the setting aside. And what we've seen now with the Yukos Russia case, this can go on for at least another decade.